Program. Well, the use of independent contractors is lucrative to many businesses given the cost and associated managerial savings. However, it's not without its risks. Employers need to be aware of the issues associated with the use of such working arrangements in the event they do get it wrong. Here to tell us more is our regular guest commentator, Joydy Paul, Managing Principal of specialist law firm People and Culture Strategies. Joydy, thanks for your time as always. We love having you on the program.
Thank you.
First of all, what are the perceived benefits of employing these independent contractors? Why do people do it?
I think from an employer's point of view, it starts with the benefit of flexibility. So you don't have someone locked in as a permanent employee. You can manage them as and when you need them. You get ancillary benefits in terms of not having to pay payroll tax. There's a lot of other advantages from a PAYG point of view. And so the bottom line benefit or perceived benefit to employers in having independent contractors as opposed to employees, not to mention that if you let an independent contractor go, they're not going to be able to come back at you for unfair dismissal and probably a range of other things as well. So they're probably the headline benefits and often very compelling for a lot of organisations.
Okay, but what does the court consider when determining whether someone is actually an independent contractor? Because it's not as clear-cut as some people might think.
It isn't as clear-cut, and so what we're seeing happen, and it's been happening for many years, is that largely off the back of these perceived benefits, employers are engaging, let's call them workers, labelling them independent contractors. Quite often it's perceived as a win-win because those independent contractors themselves like the flexibility, like being able to do the income splitting or whatever it is that they're going to do. But a court looks at an arrangement, often when the arrangement has been brought to an end and there might be some level of acrimony, say, in the relationship, which has now ended, and the worker, who was labelled an independent contractor, might turn around and say, well, actually, I want to argue that I was in fact an employee because I was working regular hours, I was working with your organisation for 9 or 10 years. Sure, you might have labelled me an independent contractor, but it didn't change the fact that I looked like an employee, I was working like an employee. You gave me a swipe card, you had my name on the company's intranet and all of those other things,
Yes.
all of the other hallmarks of an employee. And so a court will look at all of those factors and say, regardless of the label, what was the genuine nature of this relationship? And if it finds that it was in fact an employer-employee relationship, it'll say, well, you, the employer, have breached all of your obligations in relation to this person by not withholding PAYG, by not paying super, by not doing a range of other things. And what happened a couple of years ago with the introduction of the Fair Work Act was that the government said, we actually take this so seriously that we want to introduce a standalone offence called sham contracting against employers or businesses who deliberately go down this path to avoid their obligations.
But the thing is, I mean, a lot of this falls back on the employer here, but it's an agreement between the employee and the employer, and despite whether the nature of it ended up being that perhaps they didn't work like a contractor, they've still made an agreement that that would be the relationship. So surely it falls back on the employee as well.
Yeah.
They've signed that contract.
Look, you would like to think so. Unfortunately, it's never that simple, and I've seen numerous cases where a worker has signed up to the arrangement, indeed derived huge benefits from it. But when they realise that, well, the arrangement's now ended and I could have been paid annual leave, I could have been paid sick leave, I could have got long service
They're
leave.
generally paid a higher hourly rate because they miss out on those benefits.
Correct, absolutely right. But it doesn't change the fact that from a legal obligation point of view, a business or an employer can't contract out of its obligations to treat employees who are genuinely employees, legally employees, in accordance with their legal rights and obligations. So the mere fact that you've got an agreement with someone where they've said, yes, I'm an independent contractor and I'll accept a higher rate of pay instead of getting sick leave or annual leave, doesn't change the fact that that employer is in breach of their obligations in spite of that agreement with that worker.
So what are some of the consequences of misclassification?
Well, it will start with a review of all of the obligations that the employer didn't comply with. So you might have to back pay.
Yes.
All of those leave entitlements, depending on what you've done in relation to superannuation, there could be a fallout there. You could be looking at ATO consequences in terms of breaching your obligations for withholding tax. If it was a termination situation, you could be looking at redundancy pay and a range of other things. The Fair Work Act says that if you're found to have engaged in this sham contracting, the organisation and indeed individuals, and this is really important, that there could be individual liability within organisations. Penalties of up to $33,000 for each breach of the Act for sham contracting.
So sham contracting is defined as?
It's defined as an employer willfully breaching its obligations, entering into an arrangement which is properly an employer-employee relationship, but calling it an independent contractor relationship. Often you see that when an employer wants to reduce its headcount, keep someone on as a consultant or a contractor, but they're doing exactly the same thing that they were doing as an employee. Okay,
what can employers do to minimise having an independent contractor being deemed as an employee?
I think the first thing they should look at is this individual working for a range of other people as well? And that's always going to be very helpful, because part of the problem, one of the biggest problems, is that exclusivity, where a person is working only for one organisation. They're not getting income from anywhere else. Even if they're not necessarily working full-time hours, they're working pretty close there too. It's always going to be problematic. And then the other issue, I think, that the critical one, is that over a period of time, the longer the person has been working with you, the greater will be the risk. Independent contractor relationships purely should be short start and stop things, more sporadic.
Right.
If you get those kinds of things right, I think you're probably managing your risk reasonably well.
You might be in trouble, as you said, if it goes on for 10 years or something like that.
Exactly, as many of these do.
Okay, Geordie, Paul, thank you so much for joining us. Always appreciate your time on the program.
Appreciate the opportunity. Thanks.
Moving on to something